Remember in law school we had the quality of public cases? But I wish you guys had been there when I was in front of Judge Blanchard. I got up in front of the court and looked at the podium. She had the lasers in her eyes. I may as well had on her Trump hat and her red, white, blue purse. She despised me so much. When you read the recording, everything else to say counts. Your assistant would say the same thing. You got eight in his lap. Yes, nasty people. Well, Your Honor, the defense counsel was up in the school. Your Honor, I got my vaccine yesterday. And my husband was vaccinated. We get some information about that. He's vaccinated too. She said, "Sure, it's not going to make this with me." And she said, and it's not because I have you. You didn't. You. I think I always told you, Matt, and Thursday night at midnight, or I'm here at 9. That's just coincidence. Right. Can you believe COVID was like, we're all done here. Let's just call it for our hearing. What are the chances? I can't believe. It's almost like the lawsuit stuff. No. You know, it doesn't matter. You know, I mean, people do sit on the side.
All right. All the matter of people versus Michael James Gannard, 21-6186 at H. Go ahead, counsel, with your appearances, please.
Here you on behalf.
Go ahead, counsel. Mr. Gilo, you're here on behalf of the defendant, correct?
That's correct.
Mr. Rolla, you're here on behalf of the people, correct? Mr. Rolla is clearly not connected via audio. We're going to start the proceedings in this arena. Without him, sir, for the record, from the Otsego County Jail, Michael Gannard.
Yes, Your Honor.
Mr. Gannard, you're here to be arraigned on a bench warrant. You should be aware of the fact that I issued a bench warrant when you failed to appear before me in court on July 7th, 2023 for a probation violation hearing. Do you understand the basis upon which the bench warrant was issued?
Yes, Your Honor.
I'm going to set this matter for a probation violation hearing again. That will be set in person. That will be set at my next available date. Other than that, what I intend to do is simply hear some argument from each Mr. Rolla and Ms. Davis regarding bonds, and then also hear that same argument from Mr. Gilo. Then I'll set the matter for a probation violation hearing. Did you already have an attorney on your underlying probation violation matter, Mr. Gannard, you recall?
I cannot.
Mr. Gilo?
Yes. He had Mr. Brown, and he still qualifies for Mr. Brown.
All right, so we'll make sure to make that clear to Mr. Brown, and he will still be representing you for the underlying probation violation hearing, Mr. Gannard. Ms. Davis has the bond. Did you want to be heard outside of what I've already put on the record?
Your Honor, I just wanted to point out that he was released from jail after serving a 12-month sentence, failed to report. We did a show cause, he failed to report for your show cause hearing, and he asked me to complete a bench warrant. So I was going to ask for a cash surety bond, Your Honor.
All right, Mr. Rolla?
Judge, I don't know if you can hear me. I'm gonna log back in.
I can hear
I
you.
know I can't hear any of you. Part of my screen's locked.
I can hear you. I'm going to hear from Mr. Gilo then next. Mr. Gilo as to bond.
Well, as a bond judge, my client is in a situation, notwithstanding the fact he did comply with the court's order, that he does not have much in terms of money at the present time. He just got a job, and he basically is not going to be able to handle anything cash or surety. So the court would consider a PR bond, a high PR bond. That would be a appreciated so he can get to work. A job that he just got, about 2 weeks ago.
All right, thank you. Mr. Ganal, the purpose of bond is to ensure your appearance at court. I have no guarantee and no belief that you will appear in court, and that's primarily based upon the fact that for the last 9 months, you have been evading the court's authority by failing to turn yourself in on the bench warrant. Had you turned yourself in, or had I had a different information, I might be willing to consider what your attorney is suggesting. But I have to be convinced that if I let you free on any bond, particularly a promise, a personal recognizance bond, that's then likely that you would appear in court. I also have to look at public safety, and obviously, you've not been found guilty of your probation violation, but you're charged with a probation violation, and you're on probation for operating while intoxicated. Third offense, as a habitual third, subject to a maximum of 10 years in prison, and police officer assault, resist, or obstruct as a habitual third, with a maximum of 4 years in prison. The higher the amounts that you're subject to imprisonment, the more likely it is you would also fail to appear outside of already failing to appear in the past. So it's the court's belief that a $25,000 cash surety bond is appropriate in this case. That's the only amount that I would feel comfortable that if you posted it, you would have a reason to appear in court later. Therefore, that would be my order. You must appear in court at all dates stated by the court. You must also post that new bond and comply with all the terms and conditions that are indicated. I'll set that probation violation hearing at my next available date. Do you have any questions, Mr. Gilo?
No, Your Honor.
And will you, well, strike that. The court will notify Mr. Brown that he's still appointed and send him a notice for the probation violation hearing. Mr. Roll, is there anything you wanted to put on the record before we break today?
I apologize, I logged in, Judge, I could see you, but my screen was half locked. I was able to log back in, and then I heard the court's ruling. So my apologies for not being able to connect, but I was here.
All right, thank you. I was able to see you. I appreciate that. Mr. Ganad, do you have a good mailing address that's different than the one we had previously?
9215 Dundas Road, Alden, Alden, Michigan, 4912.
All right, thank you. That's where you'll get your notice in the future, Mr. Ganad. We'll see you at your probation violation hearing. Thank you, everyone. All right, court calls next matter of Moore Murphy Hospitality, doing business as Iron Pig versus the Health Department of Northwest Michigan. This is file number 23-193C. Council, Sarah, your appearance, please.
Good afternoon, Your Honor. David Delaney appearing on behalf of the plaintiff, Iron Pig Restaurant. My client, Ian Murphy, is also present. Thank you, Paul.
Deputy Judge Matthew Cross, from the Health Department, and have the Health Officer, Dan Farrell.
Thank you and welcome. So, Council, as you know, we're here on some oral argument today that was, I believe, requested by each of the attorneys. I just want to go through a brief what I have received so far and reviewed, and then I'll also oral argument to the extent that the attorneys still wanted to offer it. So, first and foremost, I received the plaintiff's, I say first and foremost, first in my stack, I received plaintiff's motion for declaratory relief. I then also received the brief and response by the Health Department. I also received and reviewed the defendant Health Department's motion for summary disposition and ultimately a reply brief filed by the Iron Pig. I've received and reviewed all of those multiple times over. I'm fairly confident in what I think the attorney's arguments are, but the purpose of oral argument is really to highlight those things that you think are most important or to add some additional substance if you wanted to. Mr. Delaney, it's your case in the sense that you filed the case. Did you have a preference for how you argued either first or last?
I will argue first, and I do not believe I will leave rebuttal.
All right, Mr. Cross, do you have an opposition to that?
That's fine, Judge. Thank you.
All right, so Mr. Delaney, I'm your oral argument for today.
Thank you. Your Honor, I know the court is well versed in this constitutional area, having previously written an opinion that was relevant. And I also know counsel for the Health Department also briefed this area very well. And so many of my arguments I would prefer to direct to the people that came to watch this hearing, members of the public, whichever side they may be on, for the government or for the business or for on either side. And I know the media is here also. So many of my arguments, the court and counsel will know well, and I'm going to stay within that time frame that you gave us. I think you allocated an hour, and I think I will be about a half an hour. But most of it is for the general public, because I want them to understand what the non-delegation doctrine means, because they hear these things in the media and on the news, and they don't understand. So let me get right to that, Judge. and of course, questions at any time. I think that historically, the most important thing to begin with is the Declaration of Independence signed on July 4th of 1976. Thomas Jefferson was the main drafter of that document. But it did not end there. After the Declaration was signed, we tore through 8 years of war with England. And I think that the general public forgets that. It was led by General George Washington. But not until that war ended did the Constitution begin to get circulated among the 13 colonies. The main drafter of that Constitution was a gentleman by the name of James Madison, who became our 4th president. James Madison was 33 years old when he wrote the U.S. Constitution with the assistance of others. And he begins that with "We the people." After the Constitution was enacted and ratified, George Washington, of course, became our 1st president, having oversaw the war after the signing of the Declaration of Independence. Both of those documents, the Declaration of Independence and the U.S. Constitution, were signed at Constitution Hall in Philadelphia, a fabulous place to visit.
Mr. Delaney,
Yes.
I'm not in need of background constitutional or historical fact.
Correct.
This case isn't about those things.
Correct.
So,
I'm ready to move on.
all right,
Thank you.
go ahead.
And as I indicated, I know the court's well versed in these things, but I wanted the public to understand. And I wanted them to understand what James Madison constructed when he put together the U.S. Constitution. And that is, he separated the branches. He had the judicial branch, which this court is in. This gentleman is in the executive branch, and I'm going to appoint this lady as the legislative branch. And the reason he separated those powers was because the king held all those powers. The legislative branch, as the court is aware, writes the laws. The executive branch enforces the law, and this court interprets the law. Michigan's first constitution was drafted in 1835 and has adopted those constitutional provisions. But Michigan has more than that. Michigan has one of the strictest separation of powers in the United States. Other states do too. And that is, Article 3 provides no person exercising one power in one branch shall exercise a power in the other branch. Now, what's important about the Constitution is, what is a law? It seems like an unusual question to be asking a court from a lawyer or lawyers that are in the courtroom. But a law, importantly, is this. It is the power to regulate people. And a law must be a law, but it leaves the capital in Lansing. It cannot become a law, which is what happened during COVID. The law was not a law. It was just a set of rules and regulations that could become law. And anytime you have that, it's not only invalid, it is not a law in this term. Now, people often complain about the legislature, they get nothing done. Maybe some of that's true. And that's exactly what's intended. At the state level, Judge, we have 110 members of the House, 38 in the Senate and the governor. All of those entities must approve a law, and they're regulated and voted out every 2 years. Madison designed that on purpose, so that the legislature would be accountable to the people. And no offense to the judicial and the executive, law writing is the most important of these areas of the branches, which are co-equal, because it regulates society. And I'll give an example for the people that are here. This nice lady, a member of the legislature, has passed a law after going through the House, the Senate, and the governor that red ties are illegal. I'm now wearing a red tie. So what's going to happen? The legislature has no power to enforce that, even though this nice lady in her act of Congress passed this law. And quite frankly, the court can't. The court can say, Mr. Delaney, red ties are illegal, you cannot wear that, but the court has no enforcement power. But that's not the case with this gentleman here, who has a firearm. And we appoint that to the executive branch so they can enforce the laws. He can immediately enforce this law, but that is the only power that he has. He doesn't have the power tomorrow to make blue ties unconstitutional or red ties or change his mind. And so each has their powers. But Madison was very good and generous to the people. I still can come back to this court, the judicial branch, and argue that the red tie law should never have been enacted by the legislature in the first place. But what happened during COVID was that all changed. The non-delegation doctrine, as the court is aware, does not allow the legislature, this nice lady, to give her law-writing power to this nice gentleman in the executive branch. The non-delegation doctrine restricts that by saying what are the standards, what's the scope, and what's the duration. the intelligible principle, which I'll come to later. But there's not only delegation, there's usurpation, which simply means that the executive branch found a law that they think applied to them and allowed them to write law. They weren't given that power, they took it. That happened in October of 2020. Most of the people in this courtroom remember what it was like during COVID in the state of Michigan. COVID tested James Madison. And in the in re certified question, the governor was acting under power given by the legislature to the governor to write laws. And every day that we woke up, whether the governor was a Republican or a Democrat or a Libertarian is irrelevant to me. But the standard for the governor was anything reasonable and necessary. That was it. See, the definition of a law is it must be a law when it leaves the courthouse, the Capitol. If the law is 75 miles an hour, that's the law. The sign can't say reasonable speed as determined by the executive branch. But that went on for months. And you couldn't visit your second home, you couldn't have motorboats. Those are all fine if they come from the legislature, which they did not. So the Michigan Supreme Court struck down the governor's power. In fact, they eradicated the entire act. It did not end there. The governor then pivoted to the health department. And the legislature, perhaps unwittingly, had written some laws that allowed the legislature, allowed the health department in the executive branch to write laws. And those mass mandates came right back. In fact, they came back over the weekend. Fast forward to January of 2022, the Iron Paper Restaurant refused to comply with the executive branch orders. They lost their liquor license, they lost their food license. They also had court-ordered mandates from Lansing to close their restaurant under threat of jail. We appealed that decision to this court on January 13th of 2022. The court looked at the law and said, the standard is this. If there's an epidemic, which isn't defined, and whenever necessary, the executive branch can issue an emergency order to prohibit the gathering of people for any purpose. Extremely broad language. And the executive branch ran with that. They closed restaurants, you had to wear masks, you had to social distance. The court struck down that law under a case of 1803 called Marbury versus Madison. Yes, that's the same James Madison. That gave this court equal co-branch power to strike down laws of the legislature that were given to the executive branch. The court also indicated in that decision that there are other statutes in the health code that will suffer the same delegation flaws. Epidemic is undefined.
The courts say that they may suffer from the same.
Yes. Okay,
But I
correct.
decline to analyze the statutes because they weren't before.
The court said they may suffer from the same fatal delegation. But the court indicated that vaping, for example, could be an epidemic, but it's unexercised but available power. So what happened next? So that's January of 2022. In December of 2022, the Court of Appeals decides the Flynn versus Ottawa case, which was the Ottawa Health Department on the west side of the state. And in that case, they did not look at the non-delegation doctrine. They simply read the statute as is, as given by the legislature to the executive branch, and said that an unelected health officer, an employee, can tell an elected board of commissioners what to do. And that's true, the law does say that. So the employee trumps the elected organization, but the people have no power there because the person is an employee. So that court said that it's not moot, which is important because I expect the health department to argue that this case is moot. But that published case in December of 22 said, look, the mask mandate has been off the books, COVID is over, we are still going to decide this case because some type of emergency order in the future is likely to recur. So they decided the merits.
Well, let's look at this case, because you cite 5 different statutes that you're asking me to find
Yes.
violative of the non-delegation clause, correct?
Correct.
2453, 2451, 2455, 5201, and 5203.
Correct.
Which of those statutes were cited by the department with respect to any of the challenged actions or the closing of the Iron Pig restaurant?
2453 and 2451 And you'll find attached to my complaint an order from the health department.
Bring us both upon 2253 as well as the local health department.
That's correct, yes.
And so it's your argument then that because those statutes, even though 2253, at least by my order at circuit court level, was excised from the statute, those still are affected and still potentially could be implicated against Iron Pig in the future if there's a new pandemic.
That's correct.
Or epidemic.
And the court's ahead of me, but reciprocity. Lansing can come, the state health code is divided into state and local. Lansing, the director in Lansing at the state level can come to the local health department and exercise the local health law. That's right in the statute.
So your interpretation of that under 2437, I'm sure is the statute you're talking about. Because there's no citation that I can find to that statute anywhere in the cases that mention it directly. But the language says that the health department, the Michigan Department of Health and Human Services can exercise any power vested in the local health department, quote, in an area where the local health department does not meet the requirements of this part. What does that mean?
Good question. That's the difficulty of that, and I don't know what that means.
What's your interpretation?
That the local health department could argue that the area of the epidemic that they have flagged is statewide, and so they don't want to exercise the power, and they prefer that the state government do it.
Well, when it says this part, shouldn't that be, or wouldn't that be referring to 2437?
2437 doesn't have any emergency powers associated with it,
Right.
So it would be a dead-end statute then.
So you view 2437 as enabling the State Department of Michigan, the Michigan Department of Health and Human Services to use any of the other statutes that still survive?
Correct.
24, 53, 51, any of them if they so choose.
Yes, and vice versa. The local health department can use the state law.
Is there any published or unpublished authority that you found from an appellate court that supports that interpretation?
No, they're been challenged.
Right, I couldn't find it. And I was interested whether or not
Right.
you found any.
I haven't seen anything like that, and we don't know the coordination between the state and local, but we know that the local acted. And actually, there is a connection. When the Iron Pig case began, they brought in a local health order, and they cited 2453 and 2451. Then the state came in and cited their portion of the statute. So they were piggybacking, if you will, on the local health department. So they both worked in concert. The local health department and then the state liquor license and MDARD on the food license all worked together under the state health code to close indoor dining and have mask mandates and regulations and things like that. So it was very circular ultimately in this case. And so either one, we could have brought in the local health department, but we took an appeal from the state health department. And that really wasn't on my radar, Judge, until a year after you ruled, when the Court of Appeals in Ottawa in the published case said, right on point, the local statute allows the health officer, and by then, quote was the year after you ruled, allows the local health department to come in and issue orders, and the Board of Commissioners, the elected board, can do nothing. And that's still the law. So the T&B case comes out, Judge, and this would have been in June of 2023. Iron Pig was actually on the same track as the T&B case, but the health department and the Attorney General rescinded their appeal. They abandoned it and the case closed, putting their hat on T&B. Well, in my view, Judge, T&B, a published case, is a mirror of this court's ruling. A year and a half after you ruled, T&B comes out and says 2253, the state version, is unconstitutional because it's a violation of the non-delegation doctrine. And in my view, Judge, they incorporated and were probably well aware of your ruling and had read it. They also said that the epidemic is undefined. And they went further than you did, because you talked about obesity and opioid and tobacco. They said loneliness could be an epidemic. And if people are lonely, then the state health department could start to take some action. And the local health department, because these laws are the same at the state and the local level. But most importantly, T&D addressed mootness and said, so long as the health department disputes the constitutionality of the statute, it's not moot. It's an actual controversy, and they do. They're here. I believe they're gonna stand up here and say, we have this power, and we wanna exercise it, and we may or may not. A decision, and I wasn't able to brief it, Judge, out of the US Supreme Court, and it was only decided March 19th of 2024, so just a few weeks ago, if that. And that's Federal Bureau of Investigation versus FIRKRE, F-I-K-R-E. And that is at 601 US space, it doesn't have a number yet, 601 US 2024, in which the FBI placed a passenger on the no-fly list. They challenged the constitutionality of the statute, and the FBI took them off the list. And a unanimous Supreme Court, I think, said, no, it's not moot because of voluntary cessation. You could put them back on the no-fly list tomorrow. And it was a constitutional question. That's what got them across the board. So to the extent that mootness and standing and those things are argued, I think that this very active FBI case would put that to rest. But more importantly,
Spell FIRKRE for me.
yes, it's FBI versus FIRKRE, F-I-K-R-E. Decided March 19th of 2024. The number is 22-1178. But I think it's on point on the address, on the issue of mootness. But look at the Ottawa case. There wasn't even a constitutional question there. And in that case, they said this is an important public issue. And there wasn't even a constitutional question. And then T&V, which finds a constitutional question, spends an elaborate amount of time talking about the fact that the case is not moot. And I think stare decisis binds the court to decide that case. There was some discussion by the health department about local legislatures are not bound by the non-delegation doctrine, which was an interesting argument. Most of the cases are decided before they were certified, but I think we can put that to bed by saying that this is state law. This is not a local ordinance that was drafted, even though a local health department has that right. It's all under the state law, and the state Department of Health can exercise those rights. And I cite the Michigan Constitution that still says, even if it were, it's the Board of Commissioners that write the law, no matter what. I mean, I don't think James Madison has ever deviated from that argument that the legislature writes the law because they're accountable to the people. And if the health department was correct about that, then a place like Wayne County that has 1.7 million people is going to be subject to these state health laws. We have 100,000 in our jurisdiction, which is Antrim, Charlotte, White, Emmet, and Otsego. Keweenaw is only 2,000 people, but I think they care. I think those 2,000 people in Keweenaw do not want to be subjected to this legislation. And so, whether or not the executive branch person is elected is irrelevant, quite frankly, because the governor was elected, and that was struck down. But here, we have an employee, and the power to write laws does not belong to the executive branch. And I think that's as clear of an argument that we can make. Now, I wanted to talk a little bit about what the court was talking about a moment ago. For the people that may not have read these laws, this nice lady gave law writing power to this nice gentleman in the executive branch. But what are the rules that he has to follow if he wants to issue an emergency order? Under 2453, which the court struck down on the state counterpart, just that there's an epidemic and it is necessary to protect health, he issues the emergency order. But who gets to decide the emergency? The people? No. The executive branch decides the emergency. So they control the definition of the emergency. 2451, declare that there's an imminent danger that a condition could reasonably cause disease. That's it. Once they make that determination, they can start issuing orders, closing restaurants, having us wear mask mandates, whatever else they want to do. But you see, as the court is well aware, this is the danger James Madison does not want. That branch has the power of enforcement, and that's where the difficulty lies. We want this officer to have a firearm because he must enforce the law, but he doesn't get the pen. He doesn't get to write the law, he gets to enforce the law. And this nice lady gets to write the laws, she has a lot of power, but she doesn't get a firearm, she can't enforce the law. And then the court gets to interpret those laws on the constitutional basis. So 2451 also allows them to prohibit the presence of individuals. Very broadly drafted, no definitions. 2455, any building that could reasonably believe to be the cause of disease based on the condition. Now that's gonna be a restaurant, or better yet, a school. If they find that COVID or some other disease or loneliness or anything that's an epidemic, they can close the school under 2455, because the building itself is the cause of the disease. 5201, if the officer reasonably believes that somebody harbors an infection, whether or not it's present. So you just look at somebody, and the other criteria is there an unwillingness to conduct himself in such a manner as to not place others at risk? That sounds a lot like COVID and social distancing. And
It seems to
again,
me a lot more clear guideposts than reasonable and necessary, though. Would you agree?
yes, but it fails the definition of a law, Judge, because it's not a law yet. And the law must be a law when it leaves Lansing. That's it. It can't become a law. And the law writing belongs to the legislature, but by doing this, they're giving the executive branch broad powers to write laws when they feel like it.
Well, it appears you recognize that there can be some sharing between the court and the branches, so long as the delegation does not violate the anti-delegation or the non-delegation doctrine. I mean, you cited the case, the imminent case from the Michigan Supreme Court.
Right.
You cited it and relied upon it in your brief. It says that you can have that coordination, you can have the delegation so long as there's some reasonable exercise of discretion or channeling of the exercise of discretion, right? So the question is, does 333.5201 have more guideposts which channel the exercise of discretion of the director, local health director, MDHA's director or otherwise, more so than 2253, which I struck down?
I think that 5201 has the word reasonably believes, and that word struck down the Emergency Powers Act. And the court got the other half of that equation by the word necessary. Reasonable and necessary were in that statute, and both those caused the demise of the statute. The court only had necessary, and that was struck down. So this is reasonable. I think reasonable is worse. It's more broad. It's in the mind of the person. And those that support the delegation of law from one branch to another, and I have found less support for that over the years, Judge, having done this for 4 years now, that I'm not the biggest fan of the non-delegation doctrine that I used to be, because it can be manipulated, and I'll come to that on the vesting clauses in a moment. But that is the law under NRA certified. But these also fall for indefiniteness. There's no time restriction here that how long these mandates can stay in place. And that causes the fatality of it. And the same with 5203. If you're determined to be a health threat to others, you get a warning notice. And it can be oral, just a verbal notice, and you're required to cooperate. I don't know what that means, but it's very broad. Then it goes on to say they can require treatment programs and require medical testing. But these laws were well intentioned in 1978, which was a long time ago, but they were never used.
Would you agree that 5203 is more protective to the individual than, for example, 2253? For example, 5203 allows the department to issue a warning notice. It allows the department to say what an individual must do, engage in testing to make sure whether there's a disease and so forth. But then for enforcement, they need to apply to the probate court. And then there's a due process right. That was an opportunity to be heard. Would you say that's more protective or less protective?
It's more, it is, right, you have the right to go to the probate court. And ironically, one of the suits I filed in this county on the school mask mandates, I filed in the probate court. And, Judge Cooper looked at it and said, no, I don't have the jurisdiction, and we came to this court. Judge Mercer was assigned to that case. So now I'm concerned about that because I did go to the probate court and I was told we don't have jurisdiction. So now what happened? And that was a written opinion by Judge Cooper. So now we have precedent in this county that really the probate court doesn't have the authority.
Well, but that wasn't on this section, right? You did file suit number 5203.
Yes,
You did.
I did. Yeah. And cited that probate section.
All right.
So-
Judge Cooper determined that the probate court did not have jurisdiction, so that
That's correct, yeah. And so that is the Let Them Breathe versus local health department, and that would have been filed in 2021 in September. So the court should be able to find that, or if you ask me to submit that to your staff, I'll do that. So the court said more of a probate court on wills and trusts and those types of things, and the state argued, the county argued, that he lacked jurisdiction. So he came to this court, under the circuit court, and I still believe that the probate court is the proper venue, but I'm
Whether
here.
or not it's probate or circuit though,
Yeah.
that the individual citizenry has the ability to redress their grievances in court. Does that make 5203 better able to survive a non-delegation challenge?
It's got a better shot at it. I'm concerned about the earlier language in there, about that they get a statement that requires the individual to cooperate. A person could just cooperate and not know they have a right to go to probate. About that. And what happens, Judge, if the health department issues an order under, and they cite 2453, 2451, 5201, 5203, and 2455. Now we've got a basket here, which is what happened on the mask mandates in the school cases. They racked up all those statutes, 2453 and 2451 for sure, imminent danger. So then what happens to the basket? Half are clearly unconstitutional and some are more suspect. But I stand on the premise that they're gonna need a lot more guidance if we're gonna allow delegation. And what they should be doing is, which is in my complaint, and we just have some limitations on our briefing, is fact finding. If the legislature says to the executive branch, if you find these facts, you can then issue this order. But I want to see court relief in 2453 and 2451, 2455. The elephant in the room is the legislature has the power right now. So if this is what the public wants, then write a law that would require mandates under certain circumstances. But as I think the court just pointed out, 2453 was the most dangerous because you can prohibit the gathering of people for any purpose, just when it's necessary for an epidemic. And if the and we were getting cases in which the courts were saying they were moot until T&B. And T&B said, we need to decide these cases. And so did Ottawa. And now the Berkey case out of the U.S. Supreme Court most recently. But the court has led me to an important area, and that is the vesting clauses of the Michigan Constitution and quite frankly the U.S. Constitution. Because I have seen courts in federal areas saying, reasonable and necessary is pretty good. That looks pretty good to me, and we think the non-delegation doctrine is malleable and is flexible, and I don't. And I'm concerned that if T&B's not in the Michigan Supreme Court, what if they say that it may certified was wrongly decided, and non-delegation is alive and well, and the health department has these powers? I didn't want the court to think I created vesting because I provided some Supreme Court briefing in which they say vesting resolves the case because law writing power is vested in the legislature, enforcement is vested in the executive, and interpretation is vested in the courts. That's it. The Constitution doesn't talk about delegation anywhere. That's a judge-created rule, no offense. in the early 1800s by the US Supreme Court. And their location is mandatory. There's no way that the executive branch has this power. They cannot share power that was given by the people. I found an interesting quote that said, when there's a pure delegation of legislative power, it's irrelevant whether the standards are adequate. They are not standards related to the exercise of executive or judicial powers. They are plainly and simply standards for further legislative power. And it doesn't help the court. I think the court demonstrated just now the difficulty of the non-delegation doctrine. Well, couldn't this be reasonable? And isn't there a little more authority here? And I think it's now, at the time I did not, but having litigated this for 4 years, including in the Court of Appeals, the intelligible principle may be on the chopping block. And Justice Gorsuch said that in the Gundy decision in the dissent. But think about this.
So while I recognize that you're trying to advocate for the change of law, I think you also recognize that I'm bound by certain questions. The legal framework that they laid out for trial courts, it's laid out for me.
Yes.
Right? I'm bound by it. I've got to go look at the scope, I've got to look at the amount of the delegation, the duration of the delegation, it's all in that opinion that I have to look at, right?
Yes, but what prohibits the court from, in the alternative, because the court has made many rulings, whether it's in a business case or an easement case, or in the alternative, the court finds this, and what do we pick up? That the court finds that if the non-delegation doctrine applies or doesn't apply, the vesting clauses should. And there's no prohibition of that. There's no case that's ruled on the vesting clauses. And you've got clear language in the Constitution that vests that power. And there it should stay. And what right does the legislature have to give power to another branch? Where does it say that? In fact, the Article 3, Section 2, separation of powers says they can't. This is a judge-made rule that's really interfering with what the plain language of the Constitution is. And I bet James Madison put those words in there for a reason. So I don't think that the court, if the court disregarded in-rate certified non-delegation, I think that would create an issue. But the Constitution doesn't have any language about delegation at all, but it has vesting. And that's the reason James Madison made it so difficult to pass a law through the House, through the Senate, to the governor, or to the president, but not so when it's an employee at the health department. And so I think that the court has authority to find in the alternative that the vesting clauses prohibit any delegation whatsoever. A few more areas, Judge, and then I will be wrapping up. The court's been generous. Certainly during COVID and during the Iron Pig cases with Ian Murphy, we heard a lot about, well, I hope you're happy now because now we have no laws at all here, and when people get sick and die, it's going to be because the Iron Pig pushed this ruling. But none of that's accurate. We still have the Emergency Management Act, which I think the court cited in its decision. The Emergency Management Act is still on the books, and that allows the executive branch to issue emergency orders at the state level and at the local level. Now, some would say, well, wait a minute, doesn't that violate what you just said about delegation? I thought they couldn't have that power. It's not a delegation because it's only good for 28 days. To me, it's a bit like the state police closing the highway. They can't close the highway, but they do because we have an emergency. Everyone respects that, and then it's opened up again. So for 28 days, the legislature has allowed an emergency order to go in place, which is a lot shorter than 280 days that we usually do. And then it gets back. See, so it's not truly a delegation.
More than just a delegation that's limited in scope.
Correct.
I'm saying the same thing.
That's right. Yes. It actually meets the criteria of the non-delegation doctrine. It's not even a delegation because it's 28 days to allow the executive branch to implement something. But after 28 days, the legislature never loses control of that power. They don't really give law writing power to the executive. So that's there right now. So if we did have a pandemic in 10 minutes, the Board of Commissioners could allow the executive branch, the mayor for the city, for example, and those two different agencies, to issue an emergency order, and the health department. So that law was looked at and in-rate certified and deemed to be a proper constitutional framework. So we are protected if we need an emergency order right now.
So Doesn't that reasoning cut directly against your suggestion, though, that this court find that no amount of delegation is allowed under the vesting clause? In other words, in recertified questions directly ruled upon a clear delegation and said because it's limited in scope, it's acceptable and it does not violate the non-delegation clause.
Yeah, I agree. I mean, Dean Murphy will tell you that I don't like the Emergency Management Act, only because of what I've read about the abuse of what's going to be the non-delegation doctrine. So I think the best way to look at it, and the court makes an excellent point, it is a contradiction of what I just argued. The vesting clauses don't allow this, and that's how I would do it. The legislature, especially now, is able to get together within hours and pass an emergency law if they needed to. If it was really that serious. And they're gonna have to fix the Constitution if they don't like it, but those are the laws that we have. And so if you give an inch, you take a mile, as they say. But I think that the best way to argue the Emergency Management Act is it's not truly a delegation. Because when you give temporary power to somebody, you're not delegating that indefinitely. And all those health laws that we just looked at are forever, whenever they feel like it. And so the true constitutionalists would say that the legislature never lost control of their law writing, and that's what the delegation clause does. It gives it away permanently. And that's kind of a test, I think, that you run into here. So you're right, I'm not a fan of the Emergency Management Act, but these laws are never tested the way they are now. And maybe your court was finding that the EMA is unconstitutional. I have to stay true to the Constitution, and I think it's got some issues, but it's on the books, and so is non-delegation. And I think social vesting also beyond there because of the indefiniteness of it. Now, I just have a few closing remarks, and I wanted to conclude where I began with three people: James Madison, Benjamin Franklin, and Thomas Jefferson. Now, the court's aware, and so is counsel, with James Madison, that said the accumulation of all powers, legislative, executive, and judiciary, in the same hands, the king, is tyranny. And I think we all experienced that during COVID. Now, Benjamin Franklin is one of the signers of the Declaration of Independence. And people said, I don't mind giving up a little bit of my liberty for knowing that the government's in control. The government's going to take care of the restaurants. They're going to take care of COVID. And so there's security in the idea that if you give up a little bit of your liberty for security, you're going to be okay. But Benjamin Franklin said this, and he was there at the signing of the Declaration of Independence. Those who are willing to forfeit liberty for security will have neither. Now, Thomas Jefferson, the drafter of the Declaration, there's a paragraph in there that I put in my complaint, and I want to summarize that and conclude. And that's this: it is the right of the people, when a long train of abuses and usurpations, which occurred during COVID, results in absolute despotism. Now, despotism in the 1700s meant tyranny. And he goes on to say this: it is their right. But he says more than that, Your Honor. It is their duty, an obligation of the people to do what? To throw off such government and to provide new guards for their future security. July 4, 1776, the Declaration of Independence. Thank you, Your Honor.
So are you arguing for an overthrow of our judicial system or just an overthrow of emergency management?
No, I think that, and I've been asked those questions recently, that if we limit law writing to the legislature, the people have the most control with the limited terms, the two houses, and the governor and the president, that we will not have these COVID issues again. I'm not here arguing that the court strike down the Emergency Management Act. It's not really part of the program. The Supreme Court passed on it, and so there it is. But I think that the court can find that the EMA is not a delegation under the non-delegation doctrine. And it also doesn't divest law writing to the executive branch because they never lose control of it. So I always tell Ian, it's a bit like him giving the keys to the dishwasher to close the restaurant up. He's given up power of control over his restaurant, but he gets those keys back in the morning. If he doesn't, if he gives them irrevocably, he's lost control of his restaurant. So I don't think it's a true delegation under that term, when the Emergency Management Act allows the executive branch to have interim orders, because the legislature gets it back. Since they never lose control, it is not a delegation.
Thank you, Council. Mr. Cross, your item.
Judge, I'll try to be relatively brief. I want to start at the outset by clarifying the issues here. I think we're more or less in agreement on how this should be framed under that intelligible principle standard that we got from the Supreme Court. But Mr. Delaney separates the complaint into the first 4 counts being under the non-delegation doctrine and the 5th count being under the vesting clauses. I would argue that he's trying to draw a distinction where none exists. I mean, these doctrines are saying the same thing. These are all sort of supported by the notion of separation of powers. We know that because Article 3, Section 2, which gives us our separation of powers, they're cited by the plaintiff in the complaint in support of both theories. So, and those doctrines are essentially the same thing. They're saying, as Mr. Delaney is arguing, that there are these clear delineations, these 3 equal branches of government are siloed. Legislator writes the laws, judicial interprets the laws, executive executes the laws, and those lines cannot be crossed. But I think the court has at least implicitly acknowledged this. That's just not how democracy actually works. There's often blurring of the lines between the 3 equal branches of government. So I would argue that there's no claim under the vesting clause. I found absolutely no authority for that in Michigan. There's not a single case that relies on the vesting clause to invalidate the statute. Not one. So I think we agree that the non-delegation doctrine and the intelligible principle standard that the Supreme Court gave us is what applies here. So, I can understand it. It's an easy argument to make. The plaintiff wants to just rest his case on T&D and Associates, NRA certified questions, and this court's previous opinion. But those involve different statutes, different scope, which I'll talk about in detail in a little bit. But a different outcome is warranted here based on the scope of this delegation. So,
well, I'm going to let you have full time here. If we need to go past the hour that I've allotted, we will. But starting with scope, how do you interpret 2437? I decided in the reply brief by Iron Pig, and I'm sure you examined it. How do you examine that? What does that statute mean?
2437 wasn't part of the complaint.
No, it wasn't. It was cited in the reply in terms of bringing up the argument by Iron Pig that if the local health department has it, then the state health department has it. In other words, when the state health department relied upon 2253 after the governor's orders were struck down by the Supreme Court, it seemed to be Iron Pig's fear that if 2253 is no longer valid, and it's not, that then the health department will rely on 2451. And it seemed to be the argument that even the state health department can rely upon 2437, which says that the department, the DHS, can exercise any power vested in the local health department. So how do you interpret that? Do you believe that that statute says the state health department can exercise any power that the local health department can? And if so, does it impact your analysis?
It doesn't impact my analysis at all, and it wasn't cited in the underlying order that is at issue in this case. I know it was cited in the response brief, but my next point was going to be the justiciability argument, and that is a clear example of there's no actual patient controversy. It's never been relied upon. It's pure speculation that it would be relied upon. So my argument would be that it's not before the court, it's not right, it's not something that we're here to decide today, but
I'll assume I disagree. What do you think the statute means?
I mean, I would agree with that interpretation, but
What interpretation?
the interpretation that the health department on the state level could exercise any authority that the local health department could exercise.
Well, help me understand this then, because I took your argument in your brief and in your motion for summary disposition to be that, as you started with today, the reason that any analysis that I had in my prior Iron Pig opinion, or the T&D Associates had because they focused on 2253, is really misplaced because the scope of 2453 or 2451 is limited to the local health department, right? So the scope, it can't affect an entire state, an entire economy. It can only affect the 3 or 4 county, whatever it is, health department of Northwest Michigan. Was that your argument?
That was the argument, yes.
If the state health department, though, can exercise the power that the local health department has, how would that be limited in geographic scope any longer?
Well, if it's, we're talking about the state exercising the same powers that a local health department could exercise. They can only exercise those powers within their territorial area.
The state has the entire territory of the state of Michigan.
It does, but in that scenario, it wouldn't be exercising the same powers that a local health department has within its locality. Again, we're talking about something that the MPHHS may conceivably use as a basis for an order. First of all, I understand you just want to answer the hypothetical. It hasn't happened yet, but if it does happen, I think we fall back under the same analysis that this court applied and T&B Associates applied regarding 2253, because it's a different provision, but we're really talking about the same thing, the same broad geographic scope. So, and the intelligible principles doctrine, that standard, the analysis is different. But we're not dealing with that. We're dealing with something that a local health department did just in its 3 or 4 county geographic area. So,
Right, but the question, of course, as you told me in your brief, and I'm sure you're going to repeat today, is it comes down to analysis of the scope, the amount of the delegation, the duration, and all sorts of factors that are under those intelligent principles. This is the scope being an important one.
Right.
So if it's limited to the four counties of the health department of Northwest Michigan, that's significantly different than if it's potentially statewide.
Right.
Again, that's why I'm asking if you agree that 2437 would give a state department health officer the ability to rely upon any of the local health department. Because that's what the statute appears to say to me. 2437 appears to say to me that if the local health department has the authority to declare an epidemic and ban the gathering of people, then the state can rely upon that local health department and exercise the authority within its jurisdiction, which is the entire state.
right. Right, but we're dealing with different scenarios, because you're talking about essentially the state relying on 2437 to take the rationale. I can go in the health department of Northwest Michigan's territory and do the same things that it could do.
I see. So you're viewing it as a state would be limited to exercising authority within the boundaries of the health department of Northwest Michigan.
Right, and I understand, of course, hypothetical to be what if the state expands that to every single health department? And then I think, again, we fall into that analysis we talked about before, the previous analysis applied by this court and T&B Associates, because we're not dealing with a limited geographic scope. So I think the analysis would be the same if that hypothetical ever actually came to pass. Because again, we're talking about a large geographic scope. They may rely on 2437 to expand this logic to every single one of the health departments. But if the state did step in and only in the locality did what the local health officer is empowered to do under 2453 or any of the other statutes challenged, then I think the analysis is the same as I advocate for in my brief, because we're talking about a limited geographic scope, and as I'll touch on a little bit, temporal limitation too. This is not boundless power. There are limits to it. So hopefully that answers the court's.
It does. Thank you.
All right, thank you, Judge. So just turning to the arguments that are in the brief, and I'll be very brief on the first one because I do acknowledge that the court probably feels like its hands are somewhat tied by the mootness, the justiciability argument because of T&B Associates. But
you seem to acknowledge that in your brief. And I know you, like Mr. Delaney, are also arguing that you think that case was wrongly decided. You're free to do that, of course. But I think it seems to me you're conceding I'm bound to find that there's not mootness because the very health statutes that were cited that are being attacked by Iron Pig were used against Iron Pig before.
right, I agree with that, Judge. This was honestly more of a preserve for appeal argument. But I did point out that, for what it's worth, again, I understand that the court's hands are somewhat tied by the higher decision. But if you look at what other states have done, understanding it's just persuasive authority on this court, they've pretty resoundingly said when these orders have been rescinded that there's no justiciable, there's no actual case or controversy. So I don't want to even belabor that point any longer. Mr. Delaney acknowledged it. I mean, in the Flynn opinion, the court confusingly sort of acknowledged that it was moot, but then went on to address the merits anyway. So I don't really have any further argument on that. So the first argument, turning to the non-delegation doctrine, again, there's really two things that the court needs to decide. I think it's a threshold matter we have to decide. Does that doctrine even apply to a locality like the health department? I cited, in the cases I cited, they speak in sweeping terms about Article 3, Section 2 of the Health and Local Government, and that is taken from the plain language of that section, that it only applies to state and local government. So I I read the the response obviously and the attempt to distinguish the cases I cited. I don't think they really did so in a meaningful way. I think it's clear that it doesn't apply to a local health department. And to take it a step back too, because I wanted to just establish one sort of foundational principle about the non-delegation doctrine, and the version of it that's advocated for by the plaintiff here. Again, it's that strict silo. You cannot cross the lines, but that's just simply not what happens in practice. The lines between the three branches of government are quite blurry, and I promise I'm not going to read you a bunch of quotes today, Judge, but there's one from the Mayor of Detroit versus State case that I thought maybe just kind of encapsulated this point perfectly. So it's a judge, a legislator, Congress. I mean, in 1789, 17 number of very, very broad officers power that was actually that's not much of a standard, and the executive protection, essentially monopoly for up to 14 years. And just one more example, in 1790, they delegated to the executive the power disabled veterans to the pension rules. And in doing that, they said that he could, quote, add to the list of invalids of the United States at such rate of pay and under such regulations as shall be directed by the President of the United States for the time being. Again, a very, very broad delegation. It's the executive's ability to choose who gets the pension, how much they get, how they get paid, and how those funds were drawn from a limited pool of resources. So obviously these aren't relics of the past. Delegations happen all the time. I read you one delegation, and we look at here in this court. The Michigan Supreme Court is empowered to enact the rules of procedure in court and even enforce those rules. If I were to get out of hand here, you could hold me in contempt. You have some enforcement power as well. Of course, we have one example here in the Public Health Code. Another easy example is MINOSHA here in Michigan. I mean, they pass their own rules, they enforce their own rules, they even serve a quasi-judicial function dealing with initial appeals. While that does ultimately go up to an administrative law judge and then I believe to the circuit court beyond that, that is pretty broad authority to give an executive agency like MINOSHA. So turning to the actual test itself, the courts acknowledge is really what applies here, and that's the intelligible principle test. So, and again, I think this is my only other quote that I'm going to read for you, Judge, but in the in-res certified questions case, they said, no valid objection can be made to delegated authority and discretion as to the execution of laws, and quote, a certain degree of discretion and thus lawmaking adheres in most executive or judicial action. And that comes again from the in-res certified questions case 506 Mich at 358. So generally, you know, the legislature, in enacting the law, it'll give you this broad, and I'll talk about what that is, it's the Public Health Code, this broad overall goal. This is what we're trying to accomplish with the Public Health Code. And then they set in place sort of guardrails to guide the executive's hand as they implement that overarching policy. So again, we look at whether the legislature, in delegating a certain amount of rulemaking authority to the executive, gave that executive intelligible principles to follow. So in doing that, and this is just sort of a summary of the case law that I cite in the brief, but there's certain considerations that the court wants us to take into account. And the first is that we have to read the act as a whole. We can't just read these provisions that plaintiffs cited in the complaint in isolation. We have to read it as a cohesive law. We have to apply a presumption of constitutionality. We can't go out of our way to find a constitutional defect when there's a reading of these statutes that would render them constitutional. We have to take into account the complexity of the topic that's being regulated, and in this case, epidemics, contagious diseases. So the level of precision required in that delegation is going to be a factor when we're looking at whether that delegation contains intelligible principles. So that the standards must be broad enough to permit efficient administration, but obviously not so broad as to leave people unprotected from uncontrolled or arbitrary power. So I just want to pause here for a second because I think part of the argument that is at the heart of this case is that the plaintiff thinks that this is the only recourse that it has to avoid being subject to these laws, and that's certainly not the case. He can anytime file a substantive due process claim. There are ways to challenge the administration of this law. I understand that's what they're trying to do here. They're trying to attack the very reason that the local health officer has this authority in the first place. But if they do find themselves subject to one of these orders, that's always an avenue available to them. But of course, understandably, they want to avoid that standard because
They already had to do it.
yeah, well, not with this order, not with the local health officer order. But I understand that this is the mechanism for them to challenge this order. If they think that it's being arbitrarily or capriciously applied to them, that's always an avenue available to them. But of course, that means all the health officer has to do is articulate a rational basis for why the order was put in place. I understand that's not why we're here, it's postured differently, but it is important to acknowledge that, this is something that they can always challenge if they are subject to a future order. But and the court's acknowledged this a couple times, the scope is relevant, and we're talking not only the geographic scope, but the moral scope. How broad is it covering the entire state? Is it a locality? Is it indefinitely, or are there some parameters on how long the order can be put in place? So just general principle is that if it is a broad delegation, because one's at issue in any certified questions and review associates statewide impacting the entire economy, we need to have some pretty precise standards there. But the exact opposite is true. That's something the court acknowledged too. If it's a narrow scope of delegation, we don't require as much precision for that delegation. So it doesn't weigh directly on the intelligible principle standard, but I cited in our brief the Jacobson case. It's a United States Supreme Court case that's over a century old. And the primary reason why I cited it, it dealt largely with what I think is a big motivator for this case and cases like it, and that is the undeniable tension between individual liberties and the common good, the community's right to combat against infectious disease. So, just like Jacobson, and I laid out in the brief too for the court's considerations that Jacobson is trying to take into account when we're dealing with laws like this. But so what the court in Jacobson said, I guess I lied. I do have one more quote for you. The court noted, quote, "In every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand." So, end of quote. So, in the Jacobson case, that was arguably a far more severe law than we're dealing with here. In that case, it was a vaccine mandate that allowed the state to fine someone for not being vaccinated. And the standard there, I think, is worth highlighting too, because the only standard on that the Massachusetts law was someone had to be vaccinated if the local board of health, quote, found it necessary for the public health or public safety. Very similar language. That is a theme that permeates all of the public health code, because this type of flexibility that we're talking about here is necessary to address rapidly evolving crises like an epidemic. So we see that this is language that's used in a lot of the other cases from other states that I cited. But ultimately, the court upheld that law in Jacobson, but did say, similar to what I'm saying here, is that there's always that arbitrary and capricious standard. And Jacobson essentially said any comparable law has to be reasonable and proportional. So with those background principles, I'm just going to talk very briefly about the specific challenges in this case. So I don't think anyone in here needs a reminder of what it was like in a really chaotic, even public officials were struggling to get their heads around exactly what they did. Community. Specifically to the public health code. General process of the legislation will say, this is our overarching goal, here are the parameters that we want you to stay in. So that goal of the public health code is to protect the safety and welfare of the people of the state, and the legislature even said in MCL 333.1111, parents 2, that we should liberally construe the public health code to achieve that goal. So I would argue first and foremost that it would be impossible to achieve that very lofty goal without affording local health officers a certain amount of discretion and authority to implement the public health code in their locality. So we have to consider too who this person is, who is the local health officer. This is a consideration that I believe it was the Indiana court that I cited in my brief that they focus very squarely on, because this isn't just someone off the street who's guessing at what might be the best thing to do to avoid the spread of disease. The public health code itself and the administrative rules implementing the public health code spell out some very specific criteria for what these people, what education and experience they have to even be the public health officer. So they have to have years of public health experience, and that's better position, certainly than me, or the court, or the legislature, or the Board of Health even, to know what is necessary in the locality. It's informed by those years of education.
I don't understand how that matters. I understand logically, emotionally, having somebody who's well qualified, and assuming your directors with the health department are to make those calls. That really doesn't answer the question, the legal question of delegation and whether or not there's proper channeling of the exercise of discretion, right? Because no matter how qualified the director is, either there's adequate standards that challenge or that channel the exercise of discretion, or there's not. I might be the most qualified health officer in the entire country, but I can't withstand constitutional challenge if there's not the guideposts. So tell me about the guideposts.
Right, and that's what I'll turn to now, but I appreciate that comment, and I understand and agree, Judge. It's simply one factor that other courts would face with non-delegation doctor challenges. That's one factor they take into consideration, and I primarily mentioned it just to give the court some background and some comfort to know that this is not like, this is someone who's more, they know what they're doing, but I agree with you.
I didn't take any of Iron Big's challenge in the first case, or in this case, to be with individual health determinations or individual health officers, or whether or not they were well qualified. I took it to be strictly legal attacks on the framework, the delegation, whether it can't withstand constitutional scrutiny. So I understand what you're saying, and there are other cases that have mentioned specifically the training that's required as being essential to, again, starting with that proposition, when we look at the act as a whole, we look at the act as a whole. But I think it still has to get down to, and I think you've acknowledged this, the average legal standards that go with the durational length. So with respect to those, help me understand how their discretion is channeled by these statutes.
Right, and I'll turn to that, and I'll address each statute side individually. So we'll start with what is the focal point of this lawsuit, and that is section 3. And just for clarification, it says that the local health officer determines that control of an epidemic is necessary to protect the public health. He or she may, by emergency order, prohibit the gathering. So applying those intelligible principles that we talked about before, my argument is that it withstands constitutional scrutiny because, again, we're reading this as a whole, as it was acknowledged. And first of all, the scope of the health officer is geographically limited. We talked about that before. It's only the locality that covers, in this case, this multi-county area. And again, that makes it very, very, very different than NRA by questions and TNV. So it's certainly warrants an analysis, and I believe a different outcome here. And my argument is that it is temporally limited. This is not indefinite power because it's limited for the period of time in which there is an epidemic and such measures are necessary. Now, I know I need to stop there because reasonable, necessary, these are words that they give plaintiffs some disease, and I understand that. But I want to focus first on epidemic because in TNV and in this court's previous opinion, there's a lot of focus on epidemic and the fact that it's not defined in the public health code. But I would argue that, again, reading this as a whole, applying that presumption of constitutionality, it's absolutely clear what it means in this context. Because let's cite to some of those examples that the TNV associates in this court cited before as things that are referred to as epidemics. Loneliness, obesity, teen vaping use. Okay. Let's bring it back to 2453. This specifically says local health inhibit the gathering of people. In what world would they apply that to teen vaping or obesity? health officer is not passing orders to prevent obese people from gathering. That's just not what the power is for. So I would say that while it's not defined in the public health code, if we look at the original understanding of what an epidemic is, the etymology of the word, it deals with communicable diseases. And that starts to make a whole lot of sense when we look at the fact that it's allowing the health officer to limit the gathering of people. And in COVID, of course, that made a whole lot of sense. I mean, this was a communicable disease that at least we knew spread from person to person. So I would argue in context, what epidemic means is clear. So
I can't really look at that though, right? I have to look at the language of the statute. I can't interpret if it's clear and ambiguous. And it says epidemic, but it doesn't provide a definition.
right, if you come to the conclusion that epidemic in this context is ambiguous, we look at the dictionary definition of that term. And I understand that if you were to look it up, because I looked at it yesterday, there are some of those same sort of broad what an epidemic means, and it will refer to it in a more figurative sense of just like a widespread condition. But again, reading it in context, reading it as a whole in the public health code, I think it's clear, even if we look to the dictionary definition, the common understanding of what epidemic means, I think it's clear in context. So those are really, I mean, those are the factors that we apply, the intelligent principles factors, and I think based on, again, the limitation on geography, the limitation on time,
What is the limitation on time?
I get distance of
Determination.
the statute, and again,
It's over.
not more. I think the medical community has resounded that it's past epidemic status at this point, but I know that in an ideal world, yes, epidemic explicitly default the health code, but how do they define that?
Wasn't the question better put that if it was defined, it would be less broad of delegation? Because it's not defined, it's a greater delegation of power. Because we use the definition to the sole person deciding what is an epidemic or what it qualifies.
I would say, yes, of course, in the absence of a definition, yeah, it's of course broader, but not unconstitutionally broad. Again, considering all of the intelligible principal factors, there's enough here to cabin the authority of the health officer, and there always gaps, these ambiguities. And yeah, it'd be nice for them to explicitly spell out everything that could possibly ever happen when that statute is. We know that's just not how the laws are written. So it is an ambiguity. It is a broader delegation than it otherwise would be if there was a definition for an epidemic. But again, I think the question is it an unconstitutional delegation, unconstitutionally broad? And I would argue it is not. So.
Beg your pardon for just a moment. Do I have Jacob Cole or Jacob Colcat here? Hearing court officer, when you have somebody new step in, would you just double check the name? I'm looking for the last name, Cole.
Yes, sir.
That's a litigant that's supposed to appear at 3 o'clock, and we're still looking before that time. It's on one of my clocks. In any event, if you see that person, let me know, please.
Yes, Your Honor.
Okay, go ahead.
Thank you, Judge. And I'll try to wrap this up.
No, I'm not trying to place any time restraints on you. I just want to be aware of my other hearing as well.
Okay, so moving on to section 20C, the provision that provides this is upon a determination by the local health department that an imminent danger to the health or lives of individuals exists in the area served by the health department, the health officer must danger, initial importantly, imminent danger in the public health code, and I think this is really reference, basically, the health officer not having a sort of provided rationale for taking any action. I don't know if it was the context of this provision, but baked into 24.1, it actually says the order that the health officer puts in place has to incorporate the findings of the health department and must require immediate action to address the imminent danger. So there is some rationale for this type of order can be put in place. And as the court noted, this isn't something that the health department can call compliance. They have to go to court to do that.
Well, let me ask a question on that, Garrett, because I'm sure you've read in section 2443 as I interpret the entirety of all of these sections, are all within either the 2450s or the 5201. 333.2443, as I read it, indicated that a violation of a regulation or a rule is punishable as a 180-day misdemeanor and a fine. My question is, first, is there a tension between a section 2451 that says, as I was questioning Mr. Delaney about previously, that says if there's enforcement sought by the department, they have to go to the probate court, and then there's notice and opportunity to be heard. Is there tension between the section 2451 that says that citizens have the right to be heard in the probate court, and 2443 that says any violation of a rule or regulation is itself a misdemeanor?
No, I don't think there's any tension there, because I think what we're dealing with are two different, we're kind of the civil remedy for the department to go to the court and say, they're not complying voluntarily, we need to tell them to comply.
Under 2451.
2451, and then the power that your honors is referencing. I don't know who that would fall to. It would fall to some prosecutor, whether it be the Attorney General's office or the county prosecutor. We're talking about criminal penalty there, and that's not something the health department, that doesn't fall into their purview at all. So,
well, that's the exact statute that was cited in 2253 and in the closure order for Mayor Pig, though, that's challenged here, right? Because the threat of jail if they're not compliant.
so that may have come from the state, but again, my focus was on what the local health officer did, and that was not cited at all. As your honor noted, it was just 2453 and 2451. Those are the only statutes that were cited in the local health department.
So there was no threat of jail in the local health department notice to the Mayor Pig?
I can tell you that. I could look at Exhibit A to the complaint.
To the complaint or to
To the complaint. Yeah, Judge, I see no record of misdemeanors, criminalities. It's 24-1, 2453. There is a 289.2113 of Michigan's food laws. Nowhere cited is there any threat of criminal penalty, which I would argue to the court that that's not a threat to the health department. And maybe they could have made IRPIG aware that, hey, this may happen to you, but it's not an authority that the health department had. I mean, they could have brought up criminal charges on IRPIG, but.
Well, the health department acted by and through the Attorney General's office in the state of Michigan. It certainly has that authority.
Sure, yes, but it's not something that this local health department would do, and it's not something they threaten to do in this case either.
Would do or could do? I guess that's the
They can't do. I don't think they have the authority to. And that would fall to whether it's a county prosecutor, Attorney General's office. That's apart from 2451. In some ways, to involve compliance. They're trying to compel. This is a civil remedy of compelling compliance, not putting them in the jail.
I see a lot of focus on the NISI question. And the reason, part of the reason that they found the delegation so broad and not capable of being salvaged is because it involved not only civil but also criminal penalties. Isn't that part of the reasoning for the very sort of questions?
I did. I didn't read that to be a focal point of either of those decisions. I think what they're really focusing on, was the broadness, the geographic broadness of the delegation of authority statewide, as opposed to what we're dealing with here, being local within a couple of counties.
I think you're taking off track. So
No, that's okay. And getting back to 2451, just very briefly applying those intelligible principles, factors. This is going to be a common theme with all these statutes, but it's limited in geography to the territory of the health officer. I would argue that the definition of imminent danger is as precise as it can be. Again, is not going to be able to formulate a law that leaves no gaps in accountability. There has to be some discretion to the executive when laws. And again, there's a safeguard there that requires the health department to behind issuing this type of order on 2451. Opportunity for the person subject to that order to challenge the order. So there are safeguards in place. 55, which again, this is another statute that's not cited. The health department's issue court side, that was relied upon them. So, to raise some sliver of room to argue justiciability, mootness, rightness, I think it rests with these three statutes. Because they remember I think if we apply the same intelligible principles that we talked about, again, common theme, limited in geographic scope to the territory of the health department. I think the language is as precise as it possibly can be. And again, this is another scenario where if you want to compel compliance, you have to go to court, where someone could raise a challenge to the basis of that order and potentially avoid compliance altogether. The final two provisions, and they were raised together, so I'll analyze them together. It's 5201 and 5203. That's that situation we're talking about where the health officer can issue a warning notice to require a person to cooperate with the health department upon the determination that the person, quote, is a carrier and is a threat to others. So both carrier and health threat to others are defined in the public health code. Mr. Delaney referenced to, there's a requirement that if someone is found to be a carrier, the notice may require them to participate in education, counseling, and treatment programs and undergo testing. And some pause there too, because I think Mr. Delaney takes issue with the idea that the local health officer can reasonably assume someone to be a carrier of a disease. And I would argue that any higher standard is completely unworkable without this provision allowing him to compel someone to test. And importantly too, this isn't a scenario where someone is sequestered as a contagious disease. Then they wouldn't be a threat to others. So this isn't that type of scenario we're talking about here. We're talking about someone who is out in the public, who believed to be a carrier of the disease, who believed them to be a threat to others. And that's a situation where the health officer could then issue a notice. Another scenario where they have to go to court to compel compliance, but then they would be able to confirm that person's status as a carrier. So again, applying those intelligible principles, standards, limited in geographic scope, and not only geographic scope to the few counties that the local health department covers, but also more precisely to people who are carriers and threats to others. That's a very, 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 very narrow subset of the population that we're talking about here. So it's very limited in scope as to who it impacts. It's as precise as it can be under this situation. And again, this isn't a scenario where it would compel anyone to leave the home and be tested. If someone wants to languish at home with a contagious disease, they're free to do so under this provision. That's not what this is aimed at. So, what I'll do, Judge, I understand that the cases that I cited from Wisconsin, Indiana, Washington, Virginia, and New Mexico, they're just persuasive authority on this court. And just in the interest of time, I know the court does have some things. I'm not rushed, but I do think it is an area that I could perhaps just breeze over. But I do think that those opinions pretty consistently upheld the type of language that's being challenged here. This, what's reasonable, what's necessary, looking at the scope of the delegation and taking into consideration things like the local health officer's qualifications. So
Is that just because, unlike Michigan, the non-delegation challenges have not risen up to those higher courts yet? We have the benefit now of PUB associates finding on me for good or for bad, saying within their certified questions. So the fact that they haven't been challenged yet, perhaps it's just because it's not far enough past the pandemic.
well, so in some of these cases, like in the Wisconsin case, the court did have a non-delegation challenge in front of it and rejected that challenge. Very, very similar, I mean, eerily similar language, where it allowed the local health officer to, quote, do what is reasonable and necessary for the prevention and suppression of disease, including forbidding public gatherings deemed necessary to control outbreaks or epidemics. And that was a non-delegation clause, non-delegation challenge. That went up to the Wisconsin Supreme Court. And the court said in the context of public health, the statute, quote, established an ascertainable general policy aimed at disrupting the transmission transmission of contagious disease. Provisions substantively restricting the local health officer and in doing so, they focus on reasonable and necessary. The Wisconsin Supreme Court said, yeah, that's good enough. I mean, because we see why we're saying that that's good enough in this context. Same considerations that Indiana, Washington, Virginia, Mexico took into account. And taking this in context, we need local health officers on the local level to have this kind of flexibility to respond to evolving crises. Because respectfully, the alternate paradigm that the plaintiff is advocating for, it just will not work. What's going to happen, there's going to be immediate logjam if we go to a legislative body and say, the health officer's order expired after 14 days, can we get an extension? Some of these bodies can't even approve budgets or to agree on what local health measures are needed. And that's what's going to happen. It's going to go to these bodies and die. So these are the considerations that the other states have taken into account. This is desirable to have this level of flexibility. It's not limitless, as the plaintiff argues. So it just, in conclusion, I think what's happening here is it's a policy disagreement that the plaintiff is trying to constitutionalize. They don't like the order, and I'm sure they're not alone in that, and I don't want to ignore the hardship that Mr. Murphy had to undergo, and business owners all over the state had to undergo during COVID. But if we apply the principles that we've been given from our higher courts, that intelligible principle standard, these statutes clearly pass muster. Could they have been more precisely drawn? Perhaps, and that would have been ideal, but then it would have potentially limited the local health officer's ability to respond in times of crises, which I think would be bad public policy. But again, anyone who's unhappy with the way the public health code currently reads, they're not without recourse. They can lobby their legislators. They can run for office themselves. They can challenge anytime they're subject to one of these orders under the supplementary process clause or any other basis they can find to challenge those orders. So I know this isn't lost on the court, and please don't take it that way, but I wanted to highlight the fact that these provisions serve a very, very vital public health function in this state. And wholesale invalidation of the provisions that are cited in the complaint will have dramatic consequences and will quite frankly leave health departments and health officers absolutely powerless to control the next epidemic when it inevitably comes. So that's all I have, Judge.
Mr. Cross, I'm interested in one final question I've got for you, which is, you came across a New York Times article recently on this case by Paul Litskin. He quoted you as, having said a couple of things. So first, I'm interested in whether you cited it, and if so, what you meant by it. So Mr. Litskin had quoted you as saying that you know that the health department is facing an uphill battle. Was that your quote?
Yeah, that was my quote.
Yes. Why are you facing an uphill battle?
Because I did go on to say that I know we're very fair and you look at this with fresh eyes, but I read
the entirety of the article.
Right. So the only thing I meant by that was I get the appeal of just looking at T&D Associates and saying 2253, 2453, 2253, 2453, they're almost identical. So that's an easy conclusion. They're similarly deficient. I never interpreted your comments to say that in the previous case, but that was certainly a focal point in the complaint. This is sort of implication that it's going to be an easy argument because look what the court's already done. So that's what I meant when I said it was an uphill battle, but as I also said in an article, I think I've put ample reasons in front of the court why this should be treated differently and why different outcomes are warranted.
Thank you, Counsel. Mr. Lane, anything you need for a brief rebuttal? Very brief, Judge. Let me just double check. We've not had any full check-in.
No, Your Honor.
The court cited, now we're looking at our phones, 333-2437. And it has some verbiage in there that I must say I was not alerted to initially. Very short section. The department, that's Lansing, in addition to any other power vested in it by law, may exercise any power vested in a local health department. That does not have that ambiguous language about, does not meet the requirements of the Act. But I would say that the state health department and the local health department has no power vested in it under the Michigan Constitution for law writing. They have other powers, enforcement, but they do not have law writing powers. And I think it's very interesting language that it must be vested by law. Twice that's in there.
Doesn't that undercut your argument that 2437 somehow creates a bigger geographical area than the state can match onto?
Correct, but the state health department, quite frankly, is going to argue, we are vested with that power. And it's gonna take me time to get to court to argue that. But I think that if the non-delegation statutes that we have gone through today are struck down as unconstitutional, then I'm not concerned at all about 2437, because the state and the local health departments will have no power vested.
Thank you. Any story about our council, I think your briefs and your oral argument today. Yeah, I like to find my, this is important to each of the parties and to this court. I'm going to issue a written opinion. I'm going to attempt my best to be brief, unlike I was in the last big case, and also to the opinion how quickly that is, I don't know for sure. But I'll get a copy to each of the attorneys. Thank you both for being here. Thank you everyone for the public who's got interest in this case as well. Floor is yours.
Thank you, Mark. Thank you, Eric.
Are you? It's been a lot of years. I up in the party. I'm not.
It's 13th district.
Oh, okay.
Thank you.
Parents with kids who feel stuff. I was like,